Yeah. Yeah. Oh, you do remember. Yeah, it was you. I got it wrong.
You know,
Two CR 1442.
Just saw it. Wow.
thank you.
Yeah.
Thank you.
They're like what I have to do.
I have to do
Wow. Oh, you really need to see that. It was awesome. It's very much awesome. All this. It was
You wouldn't be in
Oh, still. Thank you so much. And I didn't want to keep cutting like that.
No, you're good.
I let it go for a little bit. Of course. Yeah.
Luckily, they were able to get it over on the booking. Yes, are you all ready?
No, we just wanted to talk to the court for briefly. Daniel.
Thank you.
That's only one page.
Well, they already know. This is kind of the rare occasions where the client is adamant that he's not using drugs. He's been in
I'm sorry,
custody.
what?
The client's adamant that he's not using drugs.
All right, so here's, I
But no,
understand
no,
what you're
but with
saying.
that, no. And let me just proceed, Judge. So with that, I asked Daniel, and I talked to Sean about it too. He's only been in custody for about a month. Is the court, amenable to order, a follicle testing for him?
No. I mean, I'm given a choice. Here's the
Well,
thing.
no, I know,
Yeah.
but just to, I mean, it's more scientific evidence for the court.
No,
You know what I
because let
mean?
me just tell you, he was supposed to be in felony drug court, but felony drug court was at capacity.
Right.
He has been missing since, what was it? January. Here we are in August. I've given him two choices. He can either do 4 years in the prison, or either he can do felony drug court. If felony drug court doesn't accept him, he's going to safety. Those are his two choices. I'm not doing a hair follicle test. You don't get to come in and say, hey, do this or do this, because he's been missing. He hasn't
Right, but
reported.
he's somebody with mental illness, Judge, and I think that can be mitigated with that, Judge. I think there's a lot of fear, of the court and, you know, being indigent, not being able to have a phone. I mean, I completely understand, you know, not being aware that there are programs out there that can help you get a phone. I mean, you know, obviously I shed light on that with
Well,
him
see, here's the
today.
issue with that. The issue with that is.
And I'm not a, you know, I'm not a social worker, you know
Yeah.
what I mean?
But here's the issue with that. I tell everybody who's placed on probation here, if there's an issue, they can come into court and let the court know. So he knew that. And he just chose to disappear since January. So those are his choices.
And is the court amenable to allowing a tap to be done while he's in custody?
Here's what the court is going to do. He can either go to prison for 4 years, or he is going to felony drug court, or either he's going to safety. Those are his only choices. That's where we are. So I don't know what else to tell anybody. So the only thing I need is a decision from him on
Well,
what he
I
wants to
guess-
do.
Well, no, Judge, so I think it's probably best for me to just subpoena the probation officer's records, because I do believe that there are.
I
some
am not
negative-
resetting this case. I'm not giving any more settings in this case. This case has been reset and
Yeah.
reset and reset.
Understood.
So we're
It was
proceeding.
recalled. It was recalled.
All right, so he's entered his plea of true. Mr. Pettis, if you can come down, please. We're back on the record in 2022 CR 3531W, State of Texas versus Jesus Pettis. Mr. Pettis, you have two choices. One, you can either go into inpatient treatment or felony drug court. If felony drug court accepts you, they may decide to place you in inpatient treatment. They may not decide to place you in inpatient treatment. They have a dual diagnosis program where they'll take care of mental health if that's your issue, if they accept you. They don't have all the funding. They don't have all the probation officers they need. Somebody needs to write their legislature and tell them, hey, these treatment courts need more funding. If they do not accept you, you're going to safety. You understand? Do you understand?
Yes, ma'am.
Or if you want, I can sentence you, excuse me. Or if you want, I can sentence you to 4 years in prison. Which do you prefer?
Really? No,
All right, so Mr. Pettis, here's the thing, it's your choice.
yes, ma'am.
So do you want treatment or do you want to go to prison? Now, if you go to prison, they have a therapeutic community. Maybe they'll let you in the program, maybe they won't. But you have a choice, treatment or prison. Which do you choose?
Yeah, I'm trying to, it's hard for me to make a choice because I really don't know what the consequences are gonna render.
All right, so this is what I'm gonna do. I'm gonna make a choice for you. Court is finding violation of condition number 4 true. Court is going to deny the motion, alternate amend conditions to include a referral to felony drug court that's in custody. If not accepted, then safe P. All right, and we can go off the record. Here's the thing, Mr. Pettis. If you think about it and you say, you know what, I should have just accepted the 4 years in prison, guess what? Let the probation officer know. We'll bring you back and I'll give you 4 years. Do you understand?
Yes, ma'am.
All right, so here's the thing, in this court, to be successful, communication is key and you must report.
Yes,
Do you
ma'am.
understand?
Yes, ma'am.
All right, good luck to you.
Thank you and God bless you.
Oh, thank you. God bless you too.
In court, the way you dress is part of your defense. Sometimes, the first impression isn't your opening statement. It's your outfit. This is the moment where calendars become weapons. Trial dates can be a strategic advantage or a ticking time bomb for both sides. That file isn't just paper, it's a silent witness to every mistake, every missed check-in, and every broken promise.
Figured out, Judge. On the 2 indicted cases, those apparently both individuals had retained counsel
Okay.
without notice to me. So we just have the 2 night tags.
All right. So why are you leaving
I
us?
got offered a pretty swanky gig in Wilson County to go prosecute, and I'm starting there on Wednesday.
Okay, where is Wilson County?
Floresville.
I'm sorry, where?
Floresville?
Oh, how far is that from here?
About 25 minutes from here, from
Well,
downtown.
Congratulations.
Thank you. I'm excited.
They're
to
lucky
get
to
going.
have you.
Thank
I
you.
always say it's great to have a person who's been a defense attorney be a prosecutor, because you can see different things.
I agree with that. I've never prosecuted.
You're gonna have fun.
I've been doing this for over 20 years
I
and,
shouldn't say fun, but you'll see a different perspective.
well, I'm excited.
Because I hadn't done it before and I'd only worked for myself. So
That's me.
the defense attorneys and people who knew me were taking bets on whether or not I would last at the DA's office. So my very first day at the DA's office, I finished my work, right? It's 11:30 a.m. I'm like, well, this is great. And so I'm walking across the street to go to the parking garage to go, I don't know, walk in the park, watch the birds. Then I'm like, curses, I work for somebody else. And so I had to walk all the way back in the heat to the office. But you'll enjoy it.
Trade-offs, everything is trade-offs.
All right, well, have a good one and
Thank you, Judge.
enjoy. Don't be a stranger.
Thanks, not at all. I've still got some PSIs and things. I'll still be floating around the courthouse.
All right.
So.
Who's here on Nabib Garcia? All right, Mr. Garcia. Hello, what's going on with this case? Where are we on discovery?
On discovery for this case, Your Honor, I believe we have turned over everything that is in our possession. However, Mr. Garcia has a DWI with child passenger alleged to have occurred late December of 2023 that involves a blood draw, for which we still do not have a toxicology report. So I want to learn whether that toxicology report is completed. If it is, I'd like to have it so that we can consider including that as part of a plea offer in this case, or if there isn't one, why there isn't one after 8 months.
All right, so this is what the court is going to do. This is going to be the final date for discovery. After that, this case is going to keep moving through the process because it's depending on what's happening with the other cases, this is a higher level felony.
Correct.
Ms. Ferguson, can you recall this in 40 days for final discovery? And it's on Garcia. All right, and parties, this 2024 PF 08709, is that a different unlawfully carrying a weapon with a felony conviction?
Believe so. So there's only one indicted case. He has several cases pending, but the only one that's indicted is the unlawful carry of a weapon. There's the endangering the DWI. I believe there is another unlawful carry, and also there's a misdemeanor.
All right, well, if y'all will look into those matters and see what's going to happen
Yes.
in regards to those cases as well. What date, Ms. Ferguson? All right, we're going to come back on October 7th.
And so,
Or
of course, so
discovery.
we're working toward a global resolution for everything.
All right, October 7th, final discovery.
Thank you.
Thank you, Your Honor.
You're welcome.
No.
All right, who's here on Johnny Aguirre?
That's me. I'm present for Mr. Coates. John Kuntz represents Mr. Aguirre on the MTR. He was on probation out of this court on a 4-200 possession case.
Mhm.
However, he's charged with an ag assault deadly weapon that Charles Gold represents him on.
Mhm.
And on this one, I conferred with Mr. Garahan, and they just need time to look into the ag assault before deciding what's going to happen on the MTR.
All right, Ms. Ferguson, I know this was set for a contested hearing today. This will be the final setting for contested. If I can have a contested hearing on Johnny Aguirre, and we'll see where we are on that date.
Thank you, Judge.
You're welcome.
We can do September 17th.
All right, September 17th.
Sure.
Bashan, that's on Johnny Aguirre. And Norma, if you can give notification to Charles Gold on that, please. Oh my gosh, it reminds me of Danger Will Robinson, what's that? Lost in Space. You know, why didn't they just get rid of Dr. Smith? You know, I'm sorry. Just when I say rid of him, I just mean leave him on a different planet and just keep moving. What page is Aguirre on? All right, thank you.
Yeah, we'll see at 10:07 and 9:17.
All right, who's here on Jacob Rodriguez?
It's me, Judge.
Yes.
I believe Mr. Allen was here last Friday. He took the motion to set a bond on his MTR to the wrong court. It was
Yes.
signed by a judge, and then you
Yes.
said come back today.
Okay.
I did confer with Mr. Edelman. He has agreed to $10,000.
Okay, where's your client?
He is in the hallway, Judge.
All
I
right,
can
bring
bring
him
him
in.
if you need to. I
Yes.
was hopeful to get a bond set and take him through satellite.
Yeah,
Is that-
bring him,
Okay.
bring him in. Deputy Laura, they want to take this person to satellite.
They won't take them right now till after 1:30.
Okay.
And then we have to wait for satellite to contact. And then we'll put it in system.
Okay. All right, court is calling 2020 CR 2853, State of Texas versus Jacob Rodriguez. Can I have parties announce for the record for the state?
Jason
Defense.
Wolf for defense?
And are you Mr. Rodriguez?
Yes, sir.
All right, defense. Mr. Allen did come to the court, and I believe it was on Friday state. And the reason why he came to the court is because a different judge had signed on a motion to set bond. Is that correct?
I believe so, Judge.
And the defense thought it was in that court, but actually the case wasn't in that court. So have you all come to an agreement?
We have, Judge, Mr. Edelman, I believe, has agreed to a $10,000 bond. I have the motion prepared and I made those changes. I am prepared to walk him over to satellite, Judge. We are going to be making a bond for him.
All right, Mr. Rodriguez, you want to raise your hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Jacob Rodriguez.
All right. Mr. Rodriguez, have you ever been diagnosed with any mental health issues? Have you ever used any type of drugs in the past? No marijuana, nothing.
Yes.
Okay. And if you're a given bond, do you have a place to stay?
Yes, sir.
And it's the court's understanding that you all have agreed to a bond of $10,000. Is that correct?
If that's acceptable to the court.
Yes, Your Honor.
All right. Any other requested conditions of bond?
Judge, are you working? Yes. I would imagine that the court will want to keep track of him, and if he does have GPS, we would just ask for work release. Of course, he would provide that to his
Is
pre-trial
he
officer.
currently on GPS?
I don't believe that he is, but if that becomes a setting, I would just want to be hopeful that he would be allowed work release.
All right, no, I just want to know. So the only case that the court sees is this case, which is a drug case, and it's a third-degree felony. Is there anything else?
Only those cases that are pending that was the subject of this MTR, Judge. Which I believe are a couple of 1 to 4 case.
Mhm.
There's an allegation, I believe it might be THC oil, and then a UCW as a misdemeanor, Judge.
May I, Your Honor?
Yes.
For Jacob Rodriguez, possession of marijuana, 4 ounces, 5 pounds, manufactured delivered controlled substance 100, manufactured controlled substance 2 or 2A for 400, manufactured deliver controlled substance 2 or 2A for 400. You see that? And that's it.
All right, this is what the court is going to do. Court will follow your agreement, set your bond at $10,000. I'm going to ask for sober support meetings, 90 and 90 days.
Okay, Judge.
There's going to be partial GPS for employment only.
Thank you, Judge.
Is there anything else from either side?
Not from defense, Your Honor.
Nothing from state, Your Honor.
All right, then, Deputy Laura, we're off the record. Deputy Laura, is there anything that he needs?
I have the bond paperwork with me, Judge. I'm gonna walk him straight to satellite.
All right, and then here's my question, Ms. Ferguson. I see that the warrant was recalled on this case, so I guess the other cases are out there.
Thank you, Judge,
You're
for
welcome.
your time. May we be excused?
You may want to get a copy of that.
Okay, thank you, Judge.
So I have a question then. Is there an active warrant on this case at
Yes.
this time?
There's an active warrant. There's an active warrant, it's, yes, it was filed, the MTR was filed in 2023.
Should be the MTR.
But I saw that, let me see that file again.
I'm just checking to see if the warrant's on this case then.
No, because on this case, that's what I was wondering, because on this case, unless there's been a new MTR, I show that the warrant was recalled.
Okay.
But we'll check and see. We'll find
No,
out.
there was one that was recalled, but then a motion to revoke was issued just on the 7th of August.
Okay. All right, just have a seat. Thank you for dressing appropriately for court. Corey Wardlow. And after this case, we're going to take our recess. Court is calling 2024 CR 0075558, State of Texas versus Corey Lee Wardlaw. Can I have the parties announced for the record for the state?
Your Harris Settlement.
Defense?
Brian Kimbrough from Mr. Wardlaw.
And are you Mr. Wardlaw?
Yes.
Counsel, have you received all of the discovery?
I have.
Did you review it with your client?
I did.
Mr. Wardlaw, did you review the document entitled Application for Community Supervision
Yes, ma'am.
or Deferred Adjudication? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes.
Mr. Wardlaw, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams as a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Wardlow, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $2,000 fine. State recommends deferred adjudication. They're taking in consideration the following NIMAC numbers: 764, 693, 764, 694, and there's to be restitution for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea.
That is.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney?
Yes.
Did you understand it?
Yes.
Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions? Outside the agreement, the state is recommending that your community supervision be for a term of 7 years. There'll be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Stated it's open and set, Your Honor.
No, Judge.
All right, state you may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes.
Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I would ask the court to follow the plea bargain, talk to Mr. Wardlaw, believe he can complete the probation successfully. I would ask the court to consider probating part of the fine. He's currently not employed and he was, I believe, homeless at the time of his arrest. So he's got to get his feet on the ground. But he believes, he's told me that he's made a change. He's not going to be using controlled substances anymore. And he would like an opportunity to show the court.
All right, how often were you using?
About once a week now.
Do you have any children?
I do not have.
All right, if you were released, who would you be living with?
I'm my sister.
Okay, have you asked her if you can live with her?
Yes.
How far did you go in school?
I graduated high school now.
So what have you been doing with your life since graduation?
I've just been working in restaurants now.
How did you become homeless?
When I got this case, I had lost my job and I thought I lost my job. I couldn't pay the rent, so I wanted to lose my pay.
So what were you doing at this location?
I was with a friend of mine. He was, we just got off work and he was going to go pick up clothes.
They don't mention a friend in the police report. They just say, well, they do say you were in the passenger side.
Yes.
So who's your friend?
His name was Aaron Randall. He's no longer in Texas anymore.
Okay. What does your sister do?
She works at a doctor's office. I believe it's a nurse assistant.
Okay. All right, this is what the court is going to do. Court is going to sentence you to $2,000 fine that will be probated, 6 years deferred adjudication, taking consideration night mag number 764-693, 764-694, restitution to SAPD for drug testing, regular reporting by Zoom or in person, no contact with Aaron Rangel. I'm going to do a referral to felony drug court. That's to be in custody. A TAP evaluation. If not accepted into felony drug court, then that TAP evaluation will be in custody. Follow all recommendations. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Field visits. One time per month for 4 months upon release. Then at probation's discretion. And there's to be 200 hours of community service restitution. Probation, is there anything else you need?
I want to confirm the name of the no contact is Angel right now.
Is it Angel or Aaron?
Aaron Randall.
Oh, Aaron Randall.
Wrangle, right?
Randall.
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 All right, it's Aaron Randall. I thought he said Ringel.
No, I'm sorry.
And Judge, the UA.
All right, we're gonna do the UA hotline until further notice. All right, is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, we can go off the record. And this court to be successful on probation, communication is key. If you have an issue, let probation know. If you feel as though they're not addressing it, then you can always come back to court. You understand?
Yes, sir.
All right, thank you.
Thank you very much.
All right, everyone, we're going to take our break. All right, you can have a seat. And